Welcome back. This is Daybreak, and thank you for staying with us. The hashtag on X, to remind you again, is Citizen Daybreak. The SMS code is 22422 at Citizen TV Kenya and at Ayub Abdikadir. With me this morning in studio on my far right is the former Law Society of Kenya President Eric Theuri, an advocate of the High Court as well. Stephen Gikonyo joins us this morning here on the broadcast. He is political and governance commentator. And Dan Okaj is an advocate of the High Court. Gentlemen, your time is all appreciated. And good morning.
Good morning. Good morning.
Well, a lot has happened, and in many ways, this is a pointer to how our democracy is being strengthened, the accountability and openness that affairs of governance ought to be conducted. And this morning, of course, we as well will be discussing the place of Parliament and whether it's a house of convenience, given an undertaking which was historic, it did, and now how priority items are being shelved. But first, let's take a look at the highlights of yesterday and what came out of the courts. The high cost of getting rid of Gachagua, says the front page of the Standard newspaper. Above, the country's finest lawyers has been activated to litigate the case that should see the impeached DP either retire from public life or retain his seat. This, coupled with the effort, time and resources used to mobilize MPs, makes the process an expensive affair, and it's just the beginning, it says. The Daily Nation says eyes on judges. The three-judge bench presided over by Eric Ogola and also made up by Frida Mugambi and Anthony Mrima. The impeached DP yesterday stalled a petition seeking to lift the lead on an order blocking the swearing in of his successor, as he questioned the role of the Deputy Chief Justice Philomena Mwilu in naming a three-judge bench hearing the matter, while he argued that this was the exclusive mandate of the Chief Justice Martha Koome. The respondents countered the CJ had delegated. What will the court decide today? We'll of course be giving you an account of what will transpire in courts. Gentlemen, a thin line between the law and the politics done. And here yesterday there was the robust argument on both sides on whether the CJ can delegate and whether the DCJ can as well empanel the bench, and the very same bench will decide on that today. It seems that the activities of the political arena is spilling over into the precincts of the judiciary. And how do you see this panning out, given the arguments yesterday that were made in court?
Yes, thank you, Ayub, for having me. What is happening in court and what we saw yesterday, I think that's ordinary in terms of a lawyer's life. It is only because it now affects the deputy president. That's why you can see a lot of hue and cry here and there. You can see a lot of comments. But again, it's because of the nature of that seat, because and what it took to actually for that case to land there. Because, of course, it has been a national conversation. It has been something that has engraved the nation, such that whatever happens there, Kenyans are really concerned about it. But in terms of the happenings yesterday, ideally, you find that it is a false start. That is what the deputy president's lawyers are saying. It is a false start. A false start indicating that, you know, if you look at Article 160, it's very clear. And it reverberates all across Chapter 10 of our Constitution, that the judiciary is the last bastion of hope for any citizen, for any aspects of rights. And as such, the judiciary should be like Caesar's wife, beyond reproach. And to that extent, when there are question marks that like those ones that were being indicated yesterday, I think it is not a very good thing. In actual sense, we are saying it is now the judiciary that is has actually become an accused in a matter where they should be the judges. And it is not a very good thing for the courts or any judicial officer to find himself in that particular position. But again, I do not think it is just, you know, flimsy, because we have regulations, and I've told you these are things that happen. Okay. It is the first time that we are hearing, you know, a bench being constituted at night. It is the first time we are hearing issues of files being taken from a different jurisdiction, from a different area to come to Nairobi, and especially with that haste. You know, if you look at Article 160, which speaks about independence, it indicates that the judiciary cannot take directions from anyone, no one apart from themselves. Such that when you hear pronouncements, like yesterday you could see the likes of Oscar Sudi and many others saying that the Deputy President-elect will be sworn in by 2 p.m., regardless of the fact that there are proceedings in court.
And it's active.
And it's active, and we do not know. What then are they trying to tell Kenyans that they know? Actually, even if they know something, even if they've done something, even if they have pushed, it is foolish to actually come and announce it, because you are actually setting up the judiciary as against the country. And remember, we had 2007 post-election violence based on the fact that the contestants, part of them, could not trust the judiciary. So if there is an institution that should never lose the trust of this country, it is the judiciary. Because the moment you cannot resolve your things amicably through the judiciary, then it is anarchy.
All right. And Stephen, what do you make of this debate around the politics and the law? It seems one is the numerator, the other is the denominator, and depending on where you stand, the other can be the denominator and the numerator. How do you look at that fraction? Is it proper or improper?
It's an interesting mishmash.
Yeah.
And many times we'll hear what my brother here has just said, that the judiciary is now the one against the people, and you know, they met at night and so on. But under the circumstances, given that this is we've never seen anything like this before. It's unprecedented. It's high-speed activity, and everyone has to pretty much comply or adapt to the pace at which it's coming. You understand that the petitioner went in and asked for the court to hear him. He was told we cannot interfere with the process until after, and this is the after that we are now in. So had they delayed further, then everything else would have been overtaken by events. So I wouldn't blame them for meeting at any time. After all, we talk about Kenya becoming a 24-hour economy, and if that is the case, or if that is the direction we're going in, then naturally everything else has to also go to that. But I get the point he's making. If someone makes the argument that the judiciary is not being fair, then you have to also test that and see, is it actually a fact that it's not being fair? Yes.
All right. But you do understand that there are also working hours and within which you deliver your constitutional mandate. And talking about the trust that Dan has outlined, which is partly why our institutions appear to be in their current state, and the deficiency in trust when you look at it from the public perspective. Does that then mean that operational hours outside the stated hours by the law ought to be entertained in a democracy where things are happening so very fast, and there are many questions around how they are happening as to how the public views that?
There's nothing wrong with working overtime or beyond stipulated hours. And if that's what's going to hang us up, then maybe we need to make that change. I don't know that you can make a legal argument that because the judiciary or the bench met after hours, therefore it is wrong. You saw how late this process have gone, and if you leave early, perhaps someone makes a complaint that I didn't get heard. There are instances where people are sentenced or have to find bail, and because it's after 5 p.m., they have to spend the night there. Wouldn't it be wonderful if someone can be given the opportunity to pay that bond or bail as soon as the process is over? So we have to look at our country and where we want it to be and see whether there's any legal impediment by working beyond the stipulated hours.
Okay. Wakili and Deuri, can the DCJ impanel?
Ayub, I think that that is a question that is actively before the court. There has been a previous time when the DCJ has set up a panel, and the High Court, then I think it was a 5-bench, found that to be in order when it was challenged. But I know that in that case, the Chief Justice was a party. And so in law, sometimes we say you can be able to distinguish the circumstances so that even though there is a precedent, perhaps the precedent may not apply in this instance because of the question of the fact that in the previous proceedings where the High Court has said it is in order, the Chief Justice was a party, and so you know, looking at the rules of conflict of interest, it would have been somehow of a misnomer for the Chief Justice to constitute a bench to hear a matter where the Chief Justice is a party. And I think those are now the arguments that are going to be made. Well, the reading of the Constitution seems to suggest that this is a function that is bestowed upon the Chief Justice.
Okay.
If you look at the rules of interpretation of the Constitution, they are very explicit that where a power is reserved on an institution or on a person, that power can only be exercised with that and by that person. If you go to the rules of statutory interpretations, they also make that finding. But you see, these are things that have been considered before by a court, and the court has been of the view that that can be done by the DCJ. I think that perhaps what may have caught the attention of the petitioners is the fact that there were directions that were given. It appears that these directions were not received by all the parties. It appears that it was selectively on an application that had been done by the state. And I think given the nature of the application that was before the court, the intention to set aside the interim orders and the really misadvised and misguided and utterly contemptuous comments that have come from politicians around or close to the executive. You know, they began by saying the swearing in is at 10 a.m. Then they said, no, it's not going to be 10 a.m., it's going to be 2 p.m. Those kind of comments that seem to suggest that the matter has been dealt with, and the speed at which some of those things are happening is what is bringing this uproar. But I want to say something, and even my learned friend here, Mr. Okach, will confirm that sometimes, even though parties enjoy equal status before the court, the ordinary practice is that you may find, for example, a case filed by the state in terms of alleging certain urgency will be treated with much more urgency than any other case that is filed, for example, by Okach. So if I was to give an example, if Okach was to file a case in court and against a lawyer who is admitted 1 year or 2 years, that young lawyer may feel that Mr. Okach is getting certain leeway in terms of the things he can tell the court, in terms of the accommodation that he can get, and that is normal. But what sometimes we look at is not just how that, you know, how the processing is done. What we look at is, does every party then, irrespective of their status, get a square meal? And I think that is what is in play here.
Which brings us to the aspect of the merit and looking into the substance before the court.
And that's why I was saying that if we just look at sometimes how parties are treated before the court, you will get it different. For example, there are things Philomena said yesterday in court that a young lawyer saying would not have gotten away with. There are things Mwite said, there are things Githu Muigai said, and that is just the way the practice is. That the court would, okay, that's Philomena, he can say, but the question would be how the court treats it. And I agree with what Okacha said, that the circumstances of this manner have put the judiciary squarely in contest, that the confidence that the Kenyan people have in the judiciary is now in question. And I think one of the things that I've always been very consistent upon is that this case and the impeachment process is going to test all institutions. And at the end of the day, Kenyans will render a verdict. I think there's already a verdict on Parliament.
Yes.
There's a verdict on Senate.
Yeah.
And so the judiciary now is writing its own verdict on the place that the Kenyan people will give it. So my thinking would be that there is a need, and it's good that these arguments are coming up. We will evaluate the decisions that the court will make. And on merit, looking at all these circumstances, then we will be able to say that we think the court has discharged itself or it has failed to discharge itself.
Which then takes us back after this break, Stephen Dauri and Okach, when we get back to talk about that confidence amongst members of the public, because in the end, all the three arms of government draw that power from the people under Article 1 who mandate or delegate that responsibility. And we'll be talking about that because there's a concern as to the conduct of Parliament, the House, whether it's one of convenience, and what then happens, because there was a quorum aspect. There are many pending issues that are of public interest, including the deals around Adani, and some of the major occurrences happening in the country, including how we have violated Wakili, international law, given the repatriation of the Turkish nationals, and also 132 missing Kenyans, where are they, and the inability to provide answers on that. And as we finish up on this, of course, matter which is regarding the impeached Deputy President Rigathi Gachagua and the housing ruling yesterday, which was delivered by the High Court. The hashtag on next is Citizen Daybreak. The SMS code is 22422 at Citizen TV Kenya and at Ayub Abdikadir. When we get back from the break, we proceed the discussion with the Uri, Stephen, and Okachi on the broadcast. Stay tuned.